So, hello everyone. Uh, Good afternoon. This is C.R. Bhatta from West Virginia. I am a vice president of NPA and currently coordinating this year's NPA Winter Week programs. So, welcome to NPA Winter Week 2021's very first session, which is about immigration status in United States, which shouldn't be a uh, big, but still a very big deal here. So for this session, we have a very well-known name and I would say very popular among Nepali community, especially who entered here in F1 visa and looking for further career in United States. So we have attorney at law, Victoria Chen from North American Immigration Law Group. So let me tell in short about attorney Chen. Victoria Chen obtained her Juris Doctor degree from University of Minnesota Law School by attending her last year of law school at the University of Michigan, Ann Arbor. Uh, Ms. Chen has successfully petitioned more than 7,500 I-140 cases under the categories of EB1 and EB2 NIW. She has helped thousands of foreign nationals to obtain permanent residency and realize their American dreams. Ms. Chen practices exclusively in U.S. immigration and nationality law, and she is an active member of the American Immigration Lawyers Association and American Bar Association. So let's welcome Attorney Victoria Chen. Ms. Chen, microphone is yours.
All right, thank you. Hello, everyone. This is Victoria. So I'm the managing partner of North America Immigration Law Group. Some of you have already heard about us and me. So I've been a managing partner for 10 years already. I'm a member of Michigan Bar Association and American Immigration Lawyer Association. A little bit information about my firm. So our firm don't really do anything else but other than these very specific categories, such as EB1A, EB1B, EB2, and IW, and O1. So we call them talent-based visa application categories because these categories don't usually rely upon like a job offers other than EB1B. So like EB1A or EB2 and IW, they don't really rely upon job offers, US employers who sponsor. They allow self-petition. So it's a very good category, such as EB2 and IW, especially EB2 and IW is a very good category for researchers, scientists, even if you're still PhD students or you're a postdoc researchers, you can just file an IW yourself and get your green card while you are pursuing your degree or applying for jobs in the US. So we have handled more than 25,000 employment-based immigration petitions. In this year, we have petitioned more than 5,000 EB1A, EB1B, EB2, and IW, and O1 cases. A little bit advertisement, we have almost 10,000 five-star reviews in various forums and review websites because we always try to do our best for our clients. So we have incredibly high rating, and we have, I would say, a pretty good reputation in these categories. Okay, so let's jump into the green card application process. So if you want to obtain your green card through employment-based immigration category, so there are all different types of green card application category. Some people marry U.S. citizens, they can get green card through their marriages. Other people have their relatives, parents or siblings who are permanent residents or they are citizens, and they can apply or sponsor green card for foreign nationals. But for employment-based green cards, it's basically based on employment. And except for certain categories like EB1A or EB2 and NIW, they still relied upon, you still need to provide some information about your prospective appointment, what you plan to do after you get a green card, but you don't need to have a U.S. employer to sponsor you. So if you're interested in getting a green card through these categories, such as EB1A, EB2 and NIW, or EB1B, then you have to go through 2 steps. The first step is to file this form called the I-140 form. So it's a petition for alien worker. And then on the form, there are different categories that you can choose from. So if you're going to file EB2 and NIW, and you check a NIW on the form, and then you have to attach all the related documentation, evidence supporting that you're qualified for the category. And with your I-140 and NIW, let's say that you want to wait until your I-140 is approved to file your I-45, then the I-140 and NIW processing time right now is relatively long. It's about 10 months in Nebraska Service Center and more than 1 year in Texas Service Center. So there are 2 service centers adjudicating NIW cases. So one is called Nebraska Service Center, the other is called Texas. And your jurisdiction, the service center is determined by your jurisdiction, like which state you have your proposed appointment. So let's say that you have a proposed appointment in California, then your case will be routed to Nebraska Service Center. You have proposed employment in Virginia, then your case will be routed to Texas Service Center. So with your I-140 and NIW, if your party date is current, for people born in Nepal, the majority of time, the visas or party date is current for everyone under EB2, including EB2 and NIW. So you don't usually need to be worried about your party date being current. But if you have friends from India or China, you probably heard them say that, oh, if I file a NIW, then I have to wait for 9 years or 3 years to be eligible to file I-485. And that's because, you know, there are only a certain number of immigrant visas assigned to each country. And for bigger countries like India or China, there's usually a waiting period for them to file I-485 if they have an NIW approval. But, you know, for people born in Nepal or any other country, basically, other than India or China, the party date is current most of the time under EB2. And so when your party date is current and you have an I-140, you and each of your dependents can file I-485 to register permanent residence or adjust your immigration status. So dependent here, okay, approve. So dependents here mean your legal spouse. So you're married, you're a legal spouse, and any children under 21 who are not married. You know, some of our clients are so sweet. They say that, oh, can I get my parents' green card? Are they my dependents? You know, they're my family. They're alone in our home country. Unfortunately, no. So dependents for employment-based immigration purpose only includes your legal spouse and your children. If they are born outside the United States, of course, and they're under 21 and they are not married. So all your dependents and yourself will file your own I-485 application. And if your I-485 gets approved, then you get your green card. So immigration regulations allow people to do concurrent filing. So you can choose to file I-485 together or file I-485 when your I-140 is approved, or when your I-140 and NIW is pending. Most of the time, we suggest client to file I-485 after the I-140 and NIW is approved, for the reason that if you do concurrent filing or if you file I-485 before your I-140 and NIW gets approved and your I-140 gets denied, then your I-485 will automatically denied. And because I-485 is such a clear showing of immigrant intent, it might be very difficult for you to extend your F1 visa, apply for OPT, extend for OPT, or travel internationally on F1 status. So that for all these reasons, especially when clients are still in PhD program or they're on OPT, then we suggest them to file 45 after their I-140 approval. But some of our clients, they really want to do concurrent filing, usually for the reasons that they want their legal spouse to be able to work, because at the time you file 45, you can also file I-765 to get an employment authorization document. So some of our clients, they really want their spouse to have the EAD card to work, or they themselves want to have the EAD card to work. So let's say that their OPT is going to be expired, they cannot extend their OPT, or they're already in OPT extension and they are not able to find an employer to sponsor like H-1B, then they need the employment authorization document to work. So in that situation, those clients might file I-140, I-45, I-765 altogether, so that they can have the I-45 EAD card to work. So if that's the situation, then you can discuss with our attorneys, see what's the best timing for you to file I-45 and I-765. So these are the two steps. Next page. I'm trying to go to the next page.
Is it kind of frozen or?
Yeah, I'm not. So previously I just kind of click on it and it goes to the next page, but now I can annotate, but I'm not able to go to the next page.
I think there is in the left top, if you can see, you are in the writing mode. So instead of writing mode, it should be in the screen mode.
Okay.
I think so.
Oh, here you go. Okay. Yeah, so I kind of explain what Priority Date is. So if you kind of take a look at the visa bulletin, you can see all chargeability areas except those listed. So, Nepal is not one of the country listed. So you guys just need to look at the first column. So it's basically always current. C means current. So no matter you file EB-1A, EB-1B, or EB-2NIW, the priority is always current for you. Sometimes it doesn't happen very often, but sometimes there's a temporary visa retrogression under EB-2 for those born in a country other than India or China, or other than those countries listed here, like China, mainland born, India. But that's usually very short, from 1 month or 2 months. So in those months, you're not able to file 45, even if you have EB-2NIW approval or pending, but that doesn't happen very often. So if it does, then you just kind of wait until your priority is current. Usually your priority becomes current in October, because October is the first month of the fiscal year for federal government. So that's when you can expect almost guaranteed that the priority will become current again under EB-2. So yeah, more visa bulletin just in case that you're curious, but most of the time you don't need to be too worried about this. Okay, so like what I said, our firm's laser focus on certain categories, especially EB-2NIW. We file thousands of NIW cases every year with approval rate almost always 99%. So we have significant experience in this category. And this category, like what I said, is actually a very, very good category for those more in Nepal and those who are in academia. But that doesn't mean that if you get in the industry, you're not eligible for NIW anymore. But there are certain requirements for NIW, especially under the matter of Dinosaur, which is the precedent case I'm going to explain a little bit later. NIW category is almost a little bit more catered to people who are conducting research and publishing papers, because there are certain categories under the Dinosaur decision that could easily met by somebody who is, conducting research and publish papers. Our firm also handle EB1A for aliens with extraordinary ability. Most of our clients born in a country other than India or China wouldn't choose to file EB1A, but because the EB2 NIW processing time is kind of long, so we started to see more clients who are interested in EB1A, even if they were born in Nepal or Iran or another country, because EB1A has this option called premium processing. So premium processing option gives people the option to pay the USS additional $2,500, and the USS will make a decision on the case in 15 days. So decision could be upfront approval, upfront denial, or RFE, which is request for evidence. Similarly, some of our clients, they have an employer to sponsor them. So even if they were born in Nepal, they still want to file EB1B because EB1B has a premium processing option. So if you're interested in other category, any of the categories, feel free to email us for a free evaluation. We can let you know whether or not you're qualified for the category. But our general suggestion for people born in Nepal or any country other than India or China is to file EB2 NIW, just because it's easier to get approval. It allows self-petition, so you don't need an employer to sponsor you. So let's talk about EB2 NIW. This is going to be the category I'm focused on today, just because almost all of you were born in Nepal. Like what I said, this is a very good category. So this is a good category because compared to EB1A or EB1B, it has a lower standard of law. Party date is almost always current for people born in a country other than India or China. Self-petition is allowed, so it's very convenient. And basically say that I want to get a green card through an NIW, then you contact an attorney, prepare your case, or if you want to prepare and file the case yourself, and then see if it gets approved, and then you can file I-485. So remember, EB2 NIW is under EB2. So EB2 has its own requirements. So EB2 is basically second preference category. So under employment-based immigration, there's first preference, EB1, EB1A, EB1B, EB1C, second preference, EB2 NIW, EB2 PERM. So you probably heard some of your friends saying that, oh, my employer is sponsoring me green card. That's most likely through EB2 PERM, the labor certification process. And for EB2, there's a requirement called advanced degree or exceptional ability. So advanced degree means any degree above bachelor's degree. So if you have a master's, you have an MD, even if it's from a foreign country, if you can get degree evaluation to show that it's equivalent to USMD, or you have DDS, which is the dental degree. If you can get degree evaluation to show that it's US equivalent, then it's considered as an advanced degree. Then you satisfy the EB2 requirement. But some of our clients, they kind of get into the PhD program right after they got a bachelor's degree, and now they are in the PhD program. They all of a sudden want to get a green card. So in that situation, they don't have any advanced degree. In that situation, we have to either show exceptional ability, or we will take a look at our clients' work, because bachelor degree plus 5 years of post-baccalaureate experience could be equivalent to an advanced degree. So we usually look at clients' resume to determine what's the best option for them. And if you satisfy the EB2 requirement, then you move toward to the NIW requirement, which is determined by this very important precedent case called Matter of Dinosaur. So U.S. immigration law usually follows a bunch of precedent cases. That's because the law written in the written or approved by the Congress usually only give guidelines or general guidelines. So for the specific adjudication standard, the USS usually release some kind of precedent cases so that people know what specific requirements that they need to satisfy if they want to get immigration benefits under certain categories. So Matter of Dinosaur is the precedent case that we have to follow if we want to file an ADW and get an ADW approval. So yeah, these are just what I explained about advanced degree. And exceptionability. If we need to show exceptionability, then we have to look at these 6 regulatory criteria. And we have to satisfy at least 3 of them. Most of our clients will claim criterion number 5, evidence of membership, because most of our clients are have memberships in some kind of professional association. Like if you're in the field of electrical engineering, you're probably a member of IEEE. So that could satisfy 1 criterion. And criterion number 6, the significant contribution criterion, because most of our clients have publications, citations, they present in conferences, they have patents. So those are good evidence to show significant contribution. And also criteria number 1. So basically, if you have a bachelor's degree, then you satisfy criteria number 1. So these are usually the 3 regulatory criteria that we claim for clients who don't have an advanced degree and they don't have bachelor's degree plus 5 years of experience. Okay, Matter of Dinosaur. So once EB2 is satisfied, you must show that you meet the requirements of the NIW subcategory itself. NIW is evaluated based on this 3-prong test set by the Matter of Dinosaur precedent decision. So these 3-prong tests are: first, the waiver applicant's proposed endeavor must have both substantial merit and national importance. 2, the waiver applicants must demonstrate that they are well positioned to advance a proposed endeavor. And 3, the waiver applicants must demonstrate that it will be beneficial to the United States to waive the job offer and labor certification requirements. So the 3rd one is exactly why NIW can be self-petition, and you don't need an employer to sponsor you. You don't even need a job offer. And that's because the benefit of you having a green card outweighs the labor certification requirement. So labor certification is a very important process to protect U.S. Workers. You know, one of the purposes of immigration law is actually to protect U.S. workers. They don't want foreign nationals to take away, job opportunities from U.S. workers, and that's why they designed the labor certification process, which kind of ensures that no other U.S. worker is able to do the same job, and therefore, the job gives to this foreign national. And this foreign national deserves a green card because of that. But now for NIW, you don't need to show that there's no other qualified U.S. workers who are able to do the same thing. There might be a bunch of qualified U.S. workers who can do the same thing, but we still want to give green card to this foreign national because the benefits of this foreign national being a permanent resident outweighs the labor certification process. So for the 3rd prong, it's mostly arguments. Like under the 3rd prong, we put in a lot of arguments to argue that based on our clients' achievements, the urgency of the United States needs our clients' skills, their background, or their work outweighs the requirements of labor certification. So the 3rd prong kind of heavily relied upon like a lawyer's arguments. But for the 1st and 2nd prong, it will be focused on like what you plan to do, what you're currently doing, what you have achieved in the past. and whether or not we're able to utilize the information to argue that your proposed endeavor has substantial merit, it has national importance, and you're well positioned to advance a proposed endeavor. So I'm going to elaborate on all these prongs a little bit more. So for prong 1, the focus is proposed endeavor. So proposed endeavor is basically the undertaking you propose to engage after you get a green card. So it's some kind of goal or plan, the work or research that you propose to do after you get a green card. It's not limited to proposed employment. Like some immigration officer will confuse proposed endeavor with proposed employment and say that our clients don't satisfy the requirements because their proposed employment doesn't satisfy the substantial merits requirement or national importance requirements. But we're usually able to push back and argue that proposed endeavor is different from proposed employment. Proposed endeavor could be something you do or engage outside your employment. For example, if you work for Google and Google doesn't allow you to conduct research or publish papers, but you're still collaborating with your PhD advisor or other research institutions to conduct research and publish papers, then we can use that endeavor to argue that your proposed endeavor still has national importance because you continue to conduct research and publish papers. And immigration issue an RFE and say that, well, your work at Google only benefit Google. It doesn't have national importance. Then we can argue that no, in addition to our client's work at Google, he or she also does, this and that, this research with his PhD advisor. So his work still has national importance. And also we always try to push back on our client's employment endeavor not having a national importance challenge. For example, we might argue that Google is such a major player in industry, and therefore, and our clients, contributes substantially to Google, and therefore his work still has national importance. So we will throw in some of the arguments there. But at the same time, as a backup, we also suggest our client to conduct research and publish papers outside their employment so that we can argue that the endeavor still has national importance, and therefore our client's proposed endeavor has national importance. And for substantial merit, it's usually very easy to show. We have a database where we have each the substantial merit arguments for each research topics and fields. And sometimes our clients provide very good evidence for that as well. But generally, the USS just considers that most of work conducted within the STEM field has substantial merit. So we are usually able to provide good evidence for this. And for national importance, like what I said, for those working in industry, you can either show that your work offers original innovations that contribute to an advancement in the industry, or otherwise have broader implications in the field, or you can continue to conduct research and publish papers outside your employment, and we try to show national importance based on that, or we do both. And for those working in academia, it's usually very easy. As long as you continue to conduct research and publish papers, like your postdoc researchers, your PhD students, your senior researcher, then we can show that because you continue to publish papers and attend conference proceedings, you satisfy the requirement. So this prompt doesn't usually challenge for those who work in academia, but here and there we see this prompt being challenged by those clients working in industry. But the majority of the time we're able to respond to the challenges and still get a case approved. And for prompt 2, the focus is more on the individual, i.e. you. and your past successes in your field. So we basically need to argue that because you have all these accomplishments in your field, we can reasonably argue and suggest that you will continue your impactful work in the future. And therefore, you are well positioned to advance a proposed endeavor. So there are all different kinds of evidence that we're able to provide to show that you have impactful work in the field. So the evidence could be a continuous and active record of research publication and notable citations. A record of work being implemented or commercialized industry, such as patents or evidence could be patents or technology transfer agreements. Any evidence of work being used in clinical trials, like some of our clients working in the medical fields, they are engaged in clinical trials or they're involved in clinical guidelines and therefore impacting the greater medical community. Or if you have a strong educational background, while a PhD is not required, having a PhD may be considered as showing that individual is well positioned to advance their proposed endeavor. So I usually got this question from potential clients who are still in a PhD program, whether or not they should file their NIW right now, or they should wait until they get their PhD. So my answer is always that if you have a PhD, your case will be stronger because Matter or Dinosaur, Dinosaur is a person. So Dr. Dinosaur was a postdoc researcher at University of North Carolina. We found his LinkedIn profile. He was a postdoc researcher at the University of North Carolina. At the time he filed an NIW. At the time he files an NIW, I believe he has 6 citations and 3 publications. His case was denied by the USCIS, and his attorney appealed the denial decision to AAO, which is Administrative Appeal Office. So AAO determined that Dr. Dinosaur satisfied the NIW requirements because Dr. Dinosaur has strong educational background. He has a PhD, of course, as well. He's a postdoc researcher. And in addition to his publication and citations, they also have a bunch of grants, fundings that show that he's well positioned to advance his proposed endeavor. So AAO overturned the USCIS denial decision and grant the appeal for the case and used his case as a precedent case for a NIW. So now we all need to follow this case to file or argue a NIW. So education background was taken into consideration in a Dinosaur decision when it comes to the second prong. So I do usually tell potential clients that, yeah, your case will be stronger if you have a PhD, but education background is not the only way to show that you're well positioned to advance proposed endeavor. There could be a lot of things that we can use or utilize to argue that you satisfy the second prong. So for those clients who already have strong publication or citation records, they have strong evidence of implementation, they have strong evidence of grants or fundings, then it's okay that they don't have a PhD. As a matter of fact, we file so many NIW cases for clients who are still in a PhD program, especially clients from Iran. Previous, because of the travel ban, they were not able to travel internationally without a green card. So almost 90% of them file an NIW when they're still in a PhD program. Some was in the first or second year of PhD, and those clients mostly still got their NIW approved. So that kind of provides some insight of how the USCIS adjudicate cases for clients for people without a PhD. So if there are good evidence, there are good records of success of the petitioner, there's still a great chance of an NIW approval, even if the petitioner doesn't have a PhD. So again, if you want to determine whether or not you have good credentials even without a PhD to file an NIW, feel free to contact us. And the last one, any other evidence showing one is well positioned to advance proposed endeavors such as fundings, grants, and awards. So I will say fundings and awards were the primary reason AO overturned the Dr. Dinosaur's denial and decided that he was still qualified for an NIW. So if you're involved, like you can start to prepare for that now. So let's say that you want to file an NIW like next year, or before you graduate, you're still in the early stage of your PhD, just get involved in fundings. Like your PhD advisor say that, yeah, there's some kind of program, he's trying to apply for funding or grants, volunteer to help him. Say that you're happy to make some contribution, collecting data, try to write, something for your advisor. Some of our clients who are still at a very early stage of their, career kind of ask me like, what should I do to prepare for an NIW right now? I will say, just try to volunteer for any type of academic activities, like attending conferences, presenting in conferences, help with your PI, applying for fundings or grants. And all these things could be helpful to show that you're well positioned to advance proposed endeavor. And also, most important of all, try to publish more papers. Obviously, citations grow organically. There's nothing you can do about it. But yeah, try to publish more papers will be helpful for your NIW as well. And for the last prong, like what I said, most of the third prong will be based on arguments. And an immigration officer has to determine or to weigh the benefits of actions, the requirements of labor certification and the waiver of labor certification requirement, and to determine that if the petition has shown sufficient national interest benefits, and thus making it beneficial to approve the national interest waiver. So third prong is usually not challenged as a standalone. It's usually challenged if the first or second prong is not determined by the immigration officer is not sufficient. That we did not submit sufficient information or evidence to satisfy the first and second prong. Then the third prong might be challenged as well. Okay, so that's the Dinosaur decision. Like what I said, NIW is a very good category for people who are in academia or even industry, and who don't want to tie to certain employers, who are not able to get an employer to sponsor, or who simply want to apply for a green card when they are still in a PhD program or in postdoc positions, because most of the universities don't sponsor green card for postdoc researchers. Postdoc researchers are considered more temporary positions. So though for those who just want to self-petition their green cards, the NIW is a very good category. Any questions about the NIW category? No? Okay. Yeah, we can have a Q&A session after I finish the whole presentation. All right. So the next category, I kind of want to, just kind of give everybody some information, but I don't think it's the best category for everyone, just because it's very, very, very difficult to get EB1A approval. So it does have the benefit of self-petition. So like an NIW, you can self-petition your EB1A. It has the benefit of premium processing, but it's a very expensive option. You have to pay additional $2,500 to the USS. But just a very difficult category to get approval. So you might pay for the USS filing fee, the attorney fee, the premium processing fee, but still end up getting your case denied. So that's why I don't usually recommend EB1A. I usually encourage clients to initiate the green card application process earlier rather than later, so that they allow themselves sufficient period of time to have their green card or their EAD card in hand when they really need it, instead of kind of waiting until the last minute, like, oh, I cannot find a sponsor to sponsor my H-1B, my OPT expiring, I really need this green card, and they rush into the process and say that I want to file EB-1A because it has a premium processing option, and I really want my I-140 to be approved as soon as possible. That's really not a bad strategy, because like what I said, it's very difficult to get EB-1A approval. And also the whole green card application process just takes some time. So the I-485 EAD card I was talking about, it used to take 3 to 6 months to get I-485 EAD card to work. But now it could easily take 10 months or 11 months because the USS is so understaffed due to COVID, and they are just dragging their feet adjudicating EAD cards. So you kind of need to prepare yourselves for the long processing time for a green card, knowing that the green card is not something you apply today and you got it next week. That being said, if you're interested in premium processing, here's the EB-1A category. So it's a self-petition EB-1 subcategory. It's usually more ideal for people born in India or China, because remember I talked about how they had to wait for years to get their green card if they file EB-2 and W. Well, they don't need to wait if they file EB-1. So if you are interested in filing EB-1A, you have to know that you have to satisfy this 3-part analysis under this another precedent case, Kazarian versus USS. So part 1, you have to satisfy at least 3 out of 10 regulatory criteria, and then you have to pass the final merit determination. So for part 1, the immigration law lists 10 regulatory criteria and say that you have to pass at least 3 out of these 10. Some of the criteria are not pertinent to researchers or scientists, so I'm going to skip them. So usually our clients claim the criterion of number 4. Evidence that you have been asked to judge the work of others. For example, if you review papers, then you satisfy criterion number 4. And number 5, evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance. So we usually use clients' publications, citation records, any evidence of implementation to satisfy this criterion. And number 6, evidence of your authorship of scholarly articles in professional or major trade publications or other major media. So if you publish papers, you can basically satisfy criterion number 6. Most of our clients, some of our clients are able to claim the criterion of number 1, 2, 3, or 8, kind of depending on their situation. Like some of our clients that have very good awards, then we might consider criteria number 1. Other clients, they are members of associations, but only at like higher level membership. Some clients. So for example, if you're just a student member at IEEE, then you don't satisfy this criterion. It usually has to be like higher level membership, like fellow membership, then you may claim this criterion. Number 3, some of our clients have their work or themselves covered by media or featured in trade publications, then we might claim criterion number 3. And for criterion number 8 or 9 is usually for clients who are already working. They are performing, leading a critical role, or they command higher salary or remuneration, then we might claim criterion number 8 or 9. But generally we claim criterion 4, 5, and 6. And then after you satisfy the requirement, then then you have to do final merit determination. So the USS will conduct a so-called like totality test. So they will take everything, all the evidence submitted into consideration and determine whether or not, based on the evidence, that this petitioner have risen to a very tough endeavor. And not only EB1A has to satisfy this final merit determination, the EB1B category, like what I said, is a category that requires U.S. employer to sponsor, that has to satisfy this totality test as well. So usually our clients, filing EB1B sponsored by the employer will claim 2 or 3 regulatory criteria. So those criteria are very similar to EB1A. So we usually claim the criterion of scholarly authorship, the judging the work of others, and original contribution. And then we still need to argue that based on all the evidence submitted, they are considered internationally recognized as outstanding, which is the requirement for EB1B. So those are the EB1A and EB1B requirement. And for EB1, this is a question I got all the time, like, how is there any minimum requirements? Like, how would I know I'm already qualified for an IW, EB1A or EB1B? Obviously for EB1B, you need a U.S. employer to sponsor you. But how would I know that I can start to consider an IW or EB1A? Really the best way is to just email us for a free evaluation. But other than that, you can kind of take a look at your overall credentials. So these are usually things that we take into consideration when we evaluate potential clients' cases. First, whether or not you have an advanced degree or you have evidence of exceptional ability, number of publications. There's no predetermined number of publications that will guarantee like an IW or EB1A or EB1B approval. But a good rule of thumb is that for an IW, we usually suggest clients to have at least 3 or 4 publications. Obviously the more the better, but we feel that at least 3 or 4 citations kind of give us a good amount of information or research that we're able to elaborate on in the petition letters to show that our clients are well positioned to advance the proposed endeavor. Number 3, independent citation. So citations are, you're able to see your overall citation record on citation database like Google Scholars, Scopus, or different citation database. But sometimes the immigration officer wants to see independent citations. So independent citations are citations for a paper not from you yourself or your co-authors of that specific paper. So if it's co-author from another paper that you collaborated with, that's fine. But none of the citations from yourself or your co-authors of that specific paper could be considered as independent citations. So you basically need to exclude those, and then you got an independent citation number. So these kind of show your research has impact beyond your inner circle. And then we consider your prospective employment, like in a research-oriented position in your field. But now you have a question. Didn't you just say that an IW doesn't require an appointment or a U.S. employer to sponsor me or a U.S. job offer? Then why do I need to provide prospective employment information? So here, this employment information doesn't have to be a job offer. So it doesn't have to be like you already have a job offer or contract in your hand, then you're eligible to file an IW. Rather, it's kind of like your future plan, what type of employment that you wish to engage. So let's say that you're still a PhD student. You haven't even started to look for jobs. But still, immigration officer wants to know that after you get a green card, after you graduate, how are you going to continue to conduct research and publish papers? Or how are you going to continue to show that your proposed endeavor has national importance and you're well positioned to advance or propose employment? So you kind of need to give immigration officers some idea how you're going to achieve those things. So you provide your prospective employment information, Like I said, it doesn't have to be a solid job offer. It could be some communication with your potential employers in the field, some communication with your current PhD advisor, and the PhD advisor say that, yeah, after you graduate, you can stay in my lab to be a postdoc researcher. It could be a very detailed future plan statement to elaborate on what you plan to do after you graduate. So the information will be very helpful for immigration officer to determine whether or not you're well positioned to advance proposed endeavor, because the last thing immigration officer wants to see is that he or she grants you an NIW approval in the field of biomedical engineering, but then after you graduate, you decide to open a restaurant and never do any research anymore. So that's not what the USS wants. They want you to continue to work in the field of biomedical engineering, because that's why they grant you a green card. And you need to give them some information or confidence that you will do that. So that's what this means, the prospective employment, like what you plan to do. And then any other non-citation implementation evidence of your work, such as commercialized patent, technology transfer agreement, use of your work in clinical trials, things like that will be helpful. And peer reviews, like you do some paper review experience, you have some paper review experience, conference presentation, fundings, grants, awards. So those are the evidence or information we take into consideration when we evaluate potential clients' cases. And those are usually things an immigration officer will take into consideration when they adjudicate your case. So you can kind of review those things, or if you don't have any of these things, then you know the direction that you have to move towards too, if you're interested in these categories. Timelines. So most of our clients need around 1 to 4 months of active preparation to prepare their cases. After we file your case, the USS will adjudicate your case. Unfortunately, USS has been very, very slow lately. So there's a USS processing time website. So we usually provide this link to clients so that they can check the USS processing time themselves. But basically, right now, in the Brussels Service Center, an NIW takes around 10 to 15 months for processing. And for Texas Service Center, which is really crazy, it takes around 12 to 29 months. I think 29 months is over exaggerating. I don't know why they put a crazy number like that on the processing time website. But for our own cases, I think most of them were adjudicated in around 1 year or a little bit more than 1 year, not 29 months. For Nebraska Service Center, yeah, our NIW cases were mostly approved in around 11 months or so right now. But processing time changes all the time. So maybe at the time you file your case or your case is adjudicated by the USS is getting faster. EB1A has a premium processing option, but if you don't request premium processing, these are the processing times. For the I-485 processing time, the information provided by the USS processing time website is not really reliable, because now I-485 requires in-person interview. So the processing time could change based on your local USS office. So it's very hard to get a good idea like processing time, but most of our I-485 cases were processed in about 10 to 12 months, and there's no premium processing option. And like what I said, if at the time you file I-485, you can also file I-765 to get an employment authorization document. If you need to travel internationally, you can also file I-131 to get an advanced parole. It's a so-called travel document. It's usually hard to predict, but generally it takes around 3 to 6 months. But like what I said, we started to see many cases got delayed. Some of our clients need 10, 11 months to get their EAD card to work or AP to travel. For IVP, for people outside the United States, they do IVP. The processing time is about 10 months. Again, all these timelines could change. The USS processing time changes all the time. All I can say is that right now, the NetDW processing time is at the longer end of the spectrum in terms of processing time. I think in the past few years, the NetDW processing time was about 6 months or so. Sometimes it could be over 1 year, but usually only for a short period of time. So now it's definitely kind of bad time of the USS. The whole processing time is really, really long. So if you want to get your green card a little bit earlier, acting earlier rather than later is pretty important. And our timeline, a little bit advertisement again. So most of the immigration law firms don't like to put a timeline on their contract. And that's because it's very, very, very difficult to always meet the deadline of certain timelines. So if you are looking for immigration attorneys and you request to take a look at your retainer agreement, most of them probably don't really provide a timeline, but our firm do, because we want to guarantee our clients that we're going to provide the documentation within a certain period of time. So these are the timeline we put on our contract. 10 business days to draft 4 to 6 recommendation letters, 10 business days to draft the petition letter, 1 to 3 business days for revision. The last one we didn't put it there because we cannot guarantee 100% of the time, but most of the time we respond to clients' messages or inquiries within 24 business hours. Okay, back to the USS process. Then what happens after you file your I-140 and debut? So after you get your I-140 case filed to the USS, then you have to wait for the response from the USS regarding the case, which will most likely either be in approval. I should put in approval in front of RFE. So most of our cases were approved upfront, but you might get an RFE, which is request for evidence, or NOID, which is notice of intent to deny. NOID looks kind of scary, right? Notice of intent to deny, but they are very similar to RFEs. Basically, the USS officer don't want to approve the case upfront. So they want to see more evidence. So for a request of evidence, it usually gives us 84 days, but for NOID, they usually only give us 30 days. So the response timeline will be more pressing. It's very rare for the USS to deny an I-140 petition upfront. They usually give you a chance. They usually give you a chance to respond to the RFE or NOID. So RFE is basically a statement by the USS indicating that insufficient evidence was submitted, and they need more evidence. So like what I said, we usually have 84 days or 87 days to respond. And for notice of intent, the notice of intent to deny is a statement issued by the USS indicating that the USS has determined that the applicant is unlikely to meet the requirements. So this is what the USS says on their website, but in our experience, it doesn't really, there's no significant difference in terms of the approval rates between after our response between an RFE or NOID. So that kind of makes us believe that even if we get a NOID, if we're able to respond, provide sufficient information to the immigration officer, there's still a great chance of case approval, even if it seems that there's no hope for the case. It's a notice of intent to deny, but we're still able to get the cases approved after we got annoyed. Just the timeline is more pressing, like what I said. And after we respond to the RFE or NOID, the USS usually take an action within 60 days to make the final decision. This doesn't happen very often, but it does sometimes happen. What happens if the case gets denied? If I-140 is denied, you can either refile another case. Filing I-140 is not a once a lifetime opportunity. You can only do it once. So you can file another I-140 NIW, or if you want to file another I-140 under a different category, that's fine. You can appeal the denial decision like Dr. Dinosaur to AAO, or you can file a motion to reconsider the denial decision. We barely file any motion because the motion will go back to the same immigration officer that denied the case, and it's usually very, very, very rare for the immigration officer to change their own minds. So we usually refile the case or appeal a denial decision if the case gets denied. Most likely your I-140 will be approved if you work with us for your NIW. So if your I-140 is approved and your party is current, like what I said, you file your I-485. I-485 designed for people in the United States. So some of our clients, they have their legal spouse outside the United States. Then they can either get in the United States, on non-immigrant visa that allows immigrant intent, such as H4. Or they can proceed with immigrant visa processing outside the US. But if all of you are in the US, all of you file I-485, the filing fee for I-485 is kind of expensive. And our attorney fee is $1,500 for the primary, for the principal, and $1,200 per dependent. But we also have a free DIY packet that we provide to our I-140 clients for free. So you can just, if you retain us for I-140 and NIW, you don't want to spend extra money on I-485, you just use our I-485 DIY packet. And for immigrant visa processing, like what I said, designed for people outside the United States, the filing fees are actually cheaper. But our attorney fee is a little bit more expensive because for IVP, you need to collect evidence that of non-criminal record in any place that you live for at least 6 months after you turn 18. So it's kind of a lot of non-criminal records that you need to collect, or we need to help you collect and review. So our attorney fee is a little bit more expensive. And the processing time is about the same for IVP and I-485, about 10 months. Many of you are probably on F1 or J1 status. So we can focus on those. Can F1 or J1 status be extended during the process? Kind of depends. Those visas don't allow immigrant intent. So here F1, J1 also includes F2 and J2. So let's say that you're a J2 dependent of a J1 holder. These rules apply to you as well. So it kind of depends. Before you file your I-140, you are free to extend your status. So some of our clients, they decide to extend their J1 or F1 before they file their I-140 petition. Oh, keep in mind that here status doesn't mean your visa stamp. So some people confuse a visa stamp on the passport with the status. So the visa stamp on your passport doesn't determine your status. So it's only for entry purpose. After your international travel, you have to show the border officer your passport, and they have to look at your visa stamp to see if it's still valid. That doesn't determine your status. Your F1 status is determined by your I-20. So even if the F1 visa stamp on your passport is already expired, that's fine. As long as you have a valid I-20 and you continue to satisfy your F1 requirements, the terms and conditions of your F1 status, then you have a valid F1 status. Similarly, your J1 visa stamp on your passport doesn't determine your status. Your status is determined by your DS-2019 form. So as long as that form is still valid and you satisfy the terms and conditions of your J1 program, then you're on a valid J1 visa status. You don't need to renew your visa stamps just for the purpose of applying a green card or just for the purpose of staying in the US. So some of our clients, they decide to renew their DS-2019 form or extend their I-20 or apply OPT or get their OPT extension before they file their I-140. But most of the time you don't need to do that, because after you file your I-140, it's still very possible to extend your J1 or F1 status. So after you file your I-140, it's up to your university or designated visa officer to extend your I-20 or DS-2019 form. So really, if they have no problem of extending your I-20 or DS form after you file the I-140, then you can extend your status. The extension of I-20 and DS-2019 form doesn't have to go through the USS. So really nobody is reviewing those extensions, just like your university or J1 program sponsor say that, yeah, we're gonna renew your DS form or I-20 as long as you satisfy the program requirements, then you can extend those status regardless of filing I-140 and IW or not. But after you file I-45, which is the second step of your green card application, we don't really encourage our clients to extend their F1 or J1 status anymore, just because there's a clear demonstration of immigrant intent after you file your I-45, because it's the last step of your green card application. Right after I-45 approval, you get your green card, and F1 and J1, F2, J2, they require non-immigrant intent. So we're kind of worried about the contradiction of immigrant intent. So we don't encourage clients to do that. So after you file I-45, you basically cannot renew this status anymore. But if you have I-45 pending, you can stay in the US based on this pending I-45. So even if your DS-2019 form expires, you are not able to renew it, or your I-20 expires, you are not able to extend it, that's fine. You have a pending I-45, then you can stay here based on this pending I-45. And like what I said, you can file I-765 to get EAD card to work if at the time you file I-485. So the situation for F1, F2, J1, J2 during the green card application process. And here are some common questions. Most of our clients are worried that, well, what if I initiate my green card application, my case got denied? Does that mean that I have to leave the US right away? The answer is no. So the I-140 filing or approval or denial doesn't really invalidate your current visa status. If you're on F1 and you continue to be on F1, even if your I-140 and IW gets denied or your I-45 gets denied, you just stay here based on the terms and conditions of your visa. So that's why we always encourage clients to keep underlying visa status during the green card application, because let's say that you have a valid OPT until the end of 2022, and you file your green card application right now and it gets denied at the beginning of 2022, then you continue to stay here, based on your OPT until the end of 2022. Your visa status doesn't get affected by this green card application. Obviously, if your I-45 gets approved and you're a permanent resident, then you are no longer on OPT. But if the case gets denied, don't worry if you have a valid visa status and you can try it again. It will be a little bit tricky if you want to change your visa status. It wouldn't be that tricky if the visa status you're going to change into does not prohibit immigrant intent. So many of you probably will change to H-1B if you're going to work in industry or academia. So it will be okay to change to H-1B, O-1, or L-1. You can change to this visa status even if you already file your I-140 or I-485. But if you want to change to a status that does not allow immigrant intent, then your change your status application might be denied. So let's say that you want to change from F1 to J1 and you already file your I-140 and IW. it's possible that your change your status application will be denied. So if you want to change your status in the US, you have to file this form called I-539. And on the form, there is a question asking about your prior immigration petition. Similarly, if you don't want to change your status in the US, you want to leave the US, get a visa status at the US consulate and come back, you have to fill out DS-160 form. And on the form, there is a question asking about your prior immigration petition. So either way, you have to disclose your green card application, and it will be up to the officer's discretion to approve your change your status or new visa status. So that could be a little bit risky. One common issue for J1 holder is 212E, 2-year home residency requirement. You can usually figure out whether or not you're subject to 212E by looking at your DS-2019 form or your J1 visa stamp. If you are subject to 212E, then you have to either satisfy it by returning to your home country for 2 years, or you have to get J waiver before you're eligible to file I-485. But you can still file your I-140 and NIW. You're just not able to proceed with the second step. Advertisement time again. So after getting all the information, you kind of feel that, wow, I feel that I'm ready, to apply for a NIW. Seems to be a great category. I'm very interested in staying in the United States. I don't want to wait until a U.S. employer to sponsor me green card, or I feel that getting a green card or having a green card in hand will give me so much advantage looking for jobs. And you want to initiate an NIW case preparation right now, and you're looking for law firms. Our firm is kind of like a pretty good choice. So we offer very comprehensive service. We draft all the recommendation letters, testimonial letters, and petition letter, and we also respond to the RFE if we get one. We have incredibly high approval rate. I believe that we have most NIW approvals in this country compared to other immigration law firms, because we have thousands of NIW approvals every year. And this very large number of approvals kind of give us an insight into the US's adjudication trends, compared to another law firm that only got 20, 50, or even 100 NIW approvals. Our firm has 3,000, 4,000 approvals every year. So we basically know what immigration officers are looking for. Exactly. USS officers change their adjudication trends all the time. Sometimes they want to be focused on certain part of the case adjudication, or all of a sudden they are looking for a specific type of evidence. So we're able to know right away, what they are looking for, just because we have so many cases filed to the USS. And no matter what your background is, we probably have worked with hundreds or thousands of clients with, similar credentials or background as yours. Each case is carefully handled by a specific attorney that is familiar with your situation. We don't allow paralegals give legal advice. This is actually very common in immigration law firms. They just let paralegals answer legal questions or answer visa questions. We don't really allow that. I firmly believe that only licensed attorneys are eligible to answer those questions. And we offer very clear, straight deadlines for case preparation, so you can be assured that we will not endlessly delay the case. And also, we collect our attorney fee after we file the case, or by the time we file the case. So we kind of want to, prepare your case efficiently and effectively. And we try to, and most of our clients came to us, by word of mouth. I would say 98% of the time, I got a free evaluation request, and the client said that, oh, I'm referred to you by my colleagues, my neighbor, my family, my friend. So it's really a word of mouth. That's why we kind of grew substantially over the years. All right. Q&A session. Should I jump into the Q&A that I got earlier?
Thank you, Victoria. Yes, you can do like whichever is comfortable for you or whichever you want, you think might be useful for our audience.
Yeah, sure. So I can open a document
Sure.
and share with everyone.
Yes, and we have like a few more questions in chat box.
Sure. Let me see if I can.
If you want, I can share it for you.
Oh yeah, for sure.
Okay, just a second. Can you see now?
Yep.
Yeah, these are
Oh,
the
okay.
new questions. Yeah.
Oh, yeah, for sure. Yeah, I feel that for the previous questions, since we already provided the answers in the written format, maybe you could just share those with everyone else. And so that I just answer these new questions raised today.
Yes, I have already shared those questions with audience and everyone. So
Okay.
yeah, so you can answer these new questions, and if more questions, then we can discuss those. Otherwise, if you have something more to say about previous questions, yeah, feel free to do whatever you, might be good for you and our audience.
Yeah, for sure. All right, so if one is in university when he or she starts at 140 and ends up in industry during a process, does that affect a process? Oh, very good question, because it happens all the time. So first of all, after we file a case to the USS, we don't, or we're not allowed, and we're not able to provide updated information anymore. So basically, we file a case to the USS, and then the USS officer will adjudicate cases based on the information and documentation submitted. So let's say we file your I-140, you're still a PhD student, and your plan is to continue in academia. Then we will provide like a personal statement, like what I said, related evidence of those. And then you change your mind, you decide to get in industry. And in that situation, your I-140 and IW should still be adjudicated based on all the information we provided related to academia. Then at the time you file I-485, especially at the I-485 interview with the immigration officer, the immigration officer might want to know, what's your employment situation, what you were doing at that time. So in that situation, you have to provide related information to show that first, you continue to engage in the same field in this industry position. And second, your proposed endeavor still has national importance. So it comes back to my suggestion earlier about clients who are in industry. So in that situation, you probably want to continue to collaborate with your PhD advisor or other research institution. If you have ongoing projects, you can bring those, like a manuscripts or any type of plan, or a letter from your PhD advisor saying that you're collaborating on these projects and you plan to publish this in the near future if possible. So basically at the stage of I-485, although it's more like a background check to make sure that you're a decent person before they issue your green card, some immigration officer might still have the curiosity whether or not you continue to satisfy the NIW requirements. So to answer this question, it should not significantly affect your chance of getting a green card if you are able to provide sufficient information to convince the immigration officer that your being in industry doesn't affect what you plan to do, that you elaborate on in your I-140 NIW petition, i.e., you will continue to conduct research and publish papers even in industry. But if at the time we file your I-140 and IW, you are in PhD program, but you already have this plan to get into industry, then you can provide that information in your future plan statement. Say that I'm in my third year of PhD. After I graduate, I plan to work for, sorry, I use Google again, work in Google, but Google encourages their employees to attend conferences, to publish papers, to publish patents. That's what I plan to do. In addition to that, I will continue to collaborate with my PhD advisor to conduct research and publish papers. So in that situation, then the fact that you get in the industry doesn't affect the process because you already explain your plan in your I-140 and IW petition, and you're most likely wouldn't encounter any issue at the stage of I-485. Second question. I'm currently on J1 status, already filed an IW in January 2021, and on processing period. So USS is processing it. Have not applied for J waiver. My visa will be expired November 2021. Was expired, but my extended date is on 2023. Nepal this December. I probably don't suggest you travel internationally on J1 just because you already filed your I-140 and IW. Because remember, at the time you renew your J1 visa stamp, you have to fill out the S-160 form. And like what I said on the form, there is a question. I think the question is phrased as, has there any immigration petition filed on behalf of you? So if you already file your NIW, you already have to answer yes. And then it's up to the consular officer's discretion to grant the J1 visa stamp. It's possible that they denied it because J1 doesn't allow immigrant intent. So it's probably not a good timing for you to travel internationally anymore. You can take the risk, but if your J1 visa stamp gets denied, then you're kind of stuck in your home country, which is not a good situation. Number 3, on YouTube. Sure. Yeah, if you have kind of like a written document of those YouTube poster or presentation, yeah, you can include them in a summary contribution. One thing about USS is that they adjudicate cases in an extremely old-fashioned way. Because previously we have some clients, they have great TV interviews, and we try to reach out to the USS to see if we can kind of put the client's TV interview, on some YouTube video, provide them with a link, or put them in some kind of like an MP3. I'm not technology savvy, so we try to provide those evidence to the USS as well. And we got very strange response saying that no, they are not able to review any of those evidence. They only review like a print out documents. So they adjudicate cases in a very old-fashioned way. So if you have like a written documentation that we're able to include, then you can include it in your summary contribution. Number 4, how much cost? Oh, our attorney fee. Yeah, so our standard attorney fee is $5,000. But we sometimes provide some discounts. Really depends on clients' credentials. What they, the number of recommendation letters that they choose to submit. Is there a minimum number of citations for an NW? Like what I said, there's no predetermined number, but I think a good rule of thumb would be over 20 citations. That seems to be a good number. If they are not too old, some of our clients got citations from papers that are more than 10 years ago. That's probably not going to be very helpful. The USS wants to see if you're a well positioned now to advance a proposed endeavor? Can one extend his or her OPT status during the EB2 NetW? Oh, if a NetW is filed, I assume that's the question. After you file, you wonder whether or not you can still apply OPT or extend OPT after you file your I-140 and NetW. Most likely you can, if your university is able to issue you a new I-20 for your OPT or OPT extension. So basically there are two steps when you apply for OPT. You get a new I-20 from your school, and the I-20 expiration day will match your OPT expiration day. And then you file this form I-765 to the USS to get your employment authorization document, the EAD card. In our experience, the USS doesn't seem to care a whole lot about green card application at the time they adjudicate OPT. So most of our clients, even after they file their I-140 and NetW, they're still able to get their OPT or OPT extension granted. But every once in a while, very rare, but every once in a while, we heard the clients say that, well, my university will my universities ask questions about my green card application and say that if I apply for green card, they don't want to issue me a new I-20 for OPT or OPT extension. So it doesn't happen very often, but we did hear clients say that. So you can try to figure out if there's any specific policies of your university in terms of issuing a new I-20. After you file your I-140 petition, if they say that we don't have specific policy, we'll be happy to issue you a new I-20, even if you file your I-140, as long as you satisfy the terms and conditions of the OPT application, then most likely you're able to get OPT. Move. Oh, there seems to be a second part of question number 4. It's okay, you move. Basically, if you move, you will file AC-21. Not AC-21, you will file AR-11, so many forms. You will file AR-11 online, which is required for all foreign nationals. We did see, it doesn't happen very often again, but we have so many samples, so I've seen it all. We did see sometimes immigration officers issue an RFE triggered by AR-11, saying that we noticed that you filed AR-11 online and you moved. Does that mean that you change your employment? What are you doing right now? So we've seen the type of RFE, but you just need to provide your up-to-date information in RFE response. So it's not such a big deal. But yeah, overall, moving to another state doesn't affect the green card application process, especially in NetW. Like I said, it's a self-petition category, so you basically can move to anywhere, work for any employer of your choice, because it's your petition, not tied to any employer. Number 6, a group of people citing my publication, and if one or two authors are also in the same collaboration. Wow, I've never considered this. So it's kind of like a group citations, like if the citations is from a research group, and then one or two authors in the group is also in the same collaboration. I will say this is most likely considered as dependent. I've never encountered this situation. But yeah, I would think that this is considered as dependent citation. Number 7, what will happen if J1 files for I-140 and move to a different country for a different job? I-45 is designed for people in the United States, so you're not eligible to file I-45 if you're outside the United States. But like what I said, there's another procedure designed for those outside the United States. It's called immigrant visa processing. So it's okay if you move outside the United States. You just need to proceed with the immigrant visa processing if your I-140 and I-W gets approved. Usually, the requirements for immigrant visa processing are very, very similar to I-485. But if you do immigrant visa processing, that means that you probably don't have a job offer, like a U.S. job offer at that time. So you most likely want to communicate with a potential employer in the U.S. so that you can provide some information in your immigrant visa interview to show that you plan to continue to engage in the same field. Yeah, no, the I-140 is still valid. Even if you leave the US, your I-140 and I-W, which is already filed or pending or approved, is still valid. It wouldn't be invalidated just because you leave the US. This happens all the time, especially for our clients who needs to wait for their parties current. Like for a period of time, we have a very large number of clients from China. They just move outside the United States after they file their NIW, and then they wait until their party day and then start their immigrant visa processing and come back with their immigrant visa and get their green card. So yeah, it's okay to move outside the United States. It's kind of the benefits of an NIW, really. You can stay in any country during the process, as long as you satisfy the NIW requirements. Number 8. Any difference between filing I-140 on OPT and H-1B? In terms of approval rates, probably no significant difference because I-140 and I-W is focused on your credentials. What it might affect is your capacity to travel internationally. So back to the earlier question about travel internationally on J1 after file the I-140 and I-W. Yeah, it's not recommended to travel internationally if you're on F1 or J1 after you file I-140, but it wouldn't be an issue if you're on H-1B. So that's probably the primary difference. If the PhD dissertation considered as a publication, if the PhD dissertation is published, I know that some dissertations are published. So if it is published somewhere, then it's counted as publication. If not, then no. But the citations accumulated toward the dissertation can be counted toward the overall citation record. Number 9, what is the current processing time for I-485? That was filed after 3 months of filing I-140. The USS basically wouldn't really look at your I-485 until your I-140 gets approved. So you will just continue to be pending, and depending on when your I-140 gets approved, they will take a look at your I-485. And at that time, yeah, it might still take 10 to 12 months. Yeah, the USS is so slow right now. So yeah, the whole processing time is really long. Number 10, is there a way where the application fee can be waived? Yeah, I believe so. I've seen it on the USS website. We've never successfully claimed it. I know we try to request a waiver of application fee for some of our clients, but they are always rejected. But I know that the USS website said that, if you have like some reasons that you can request it, but they rarely waive it. Number 11, citation needed to be first, second author. Nope. Any citations from any papers, as long as you're listed as the author, could be counted toward your application. Our collaboration papers and citation equally count as first, second author paper citations. Yeah, I know some immigration officers are more focused on like the first author papers, and they think that our clients deserve more credits, or they only deserve credits if they are listed as the first author on the paper. But we're usually able to push back the arguments. So we just say that, um, research projects require collaboration, and the fact that our clients are now listed as the first author doesn't mean that he or she didn't make contribution. So we're usually able to successfully push back on those immigration officers' challenges. So yeah, I would say most likely they're viewed equally. Number 12, can I-140 and I-45 be filed together? Yep. When your party is current, you can file I-140, I-45 concurrently. And can it be filed shortly after filing I-140? Yep. As long as you file I-45 after or together with your I-140, yeah, you can file I-45 anytime if the party is current. Any risks? Yeah, if you file I-45 before your I-140 gets approved and I-140 gets denied, then you lose your filing fee. And like what I said, if you're on a visa that doesn't allow immigrating 10, such as F1, F2, J1, and J2, it might be difficult for you to extend your status. Number 13, can we travel after approval of I-140? Depends on your visa status. If you're on H-1B, which allows immigrating 10, then that's fine. If you're on F1, F2, J1, J2, then no. We suggest you not to travel internationally until you get AP. You can get AP by filing I-131 together with I-485. Number 14, can one of the projects be made out of unpublished work? Yeah. And ongoing projects. So I assume you're asking about projects in summary contribution. Yeah, you can include an unpublished work like ongoing projects in your summary contribution as one of the projects. Okay. Any other questions? Oh, if the research field is slightly changed, then the publication citations from a little bit different fields are counted the same, or all citation research should be exactly the same field. Oh, in that situation, we will try to claim a broader field so that we can include all your publication and citations, because we never want to exclude any publication or citations. We want to present your case in the strongest way possible. So if you change your research topics a little bit, then we will try to figure out the field that can cover all your research topics so that we can include all your publication and citations and give you the best chance of case approval. Number 16, processing time. Yeah, so 10 to 12 months processing time is usually after the US says review your I-485. And like what I said, you don't usually review I-485 until your I-140 gets approved. Even if you do concurrent filing, i.e., concurrent filing doesn't necessarily save on the overall processing time. You probably save a little bit because at the time your I-140 is still pending, you can do fingerprint for your I-45. FBI can do background check, but that doesn't save a lot of time. It probably save a couple of weeks. So yeah, the overall processing time doesn't substantially get shorter if you do concurrent filing. So most of our clients do concurrent filing really for other reasons, that they need a pending I-45 to stay in the US, or they need a EAD card to work, or their spouse need a EAD card to work. Number 17, switch jobs. Yeah, like what I said, yeah, you can change jobs during your I-140 and NIW I-45 pending. You just need to continue to satisfy the NIW requirement. Number 18. So you're on F1 status. Before I-45 approval, can we file I-45 and get travel document to travel internationally? Yeah, the travel document is filed together with I-45, so you can do that. But keep in mind that once you enter the United States on your AP, you invalidate your underlying visa status, which means your F1 will no longer be valid. In that situation, because you already filed I-45, and remember what I said, if you have a pending I-45, you can stay in the US. So you basically just relied upon the pending I-45 to stay in the US. And if you already file I-765 to get EAD card, you can use that EAD card to work, if you need to work at that time. But it's not the most ideal situation if your I-140 is still pending, because if your I-140 and NIW gets denied, your I-45 will be automatically denied. So you don't have anything. You don't have underlying visa status because your F1 is already invalidated upon your entry on AP. Then you have to leave the US. So my suggestion, if clients really, really want to get AP or do concurrent filing or use your EAD to work or use your AP to travel internationally, is you can do concurrent filing. You file I-140 and I-45, I-765, I-131 all together, or you file them, the I-45 when your NIW is still pending, but refrain from using your EAD to work or AP to travel until your I-140 gets approved. Because if your I-140 and NIW is approved, 99.99% of the time, your I-45 will also be approved. Because I-45, like what I said, is more like a background check. So most of our clients don't really have any problems passing those background checks. So it's almost just like a matter of time to get I-45 approval. If your I-140 and NIW is approved, so in that situation, you can kind of use your EAD card to work or AP to travel internationally. 19, is it possible to apply to H-1B? Yep. H-1B allows immigrant intent, so no problem getting H-1B after you file I-140 or even I-45. 20, need some references. Who can be our reference? Oh, like a recommenders. If you need, we do usually submit some recommendation letters for our NIW petitions, and those recommendation letters can come from your supervisor, your collaborator, people citing your papers, other experts in your field. Usually we want to focus on so-called independent recommenders, people who have never worked with you, never collaborated with you. So let's say that we submit 4 recommendation letters, then we will suggest maybe 2 or 3 independent recommendation letters from people who have never worked with you, and just 1 or 2 from like your supervisor or collaborator. Number 21, can you change your job status after I-45 is approved? Yep. After I-45 approval, you're a green card holder. You can change jobs, you can move, you can, stay in the US. And we usually suggest clients to stay in the same field, not the same job. You can change jobs, but we suggest clients to stay in the same field that we claim on their I-140 petition for at least 6 months after they get a green card. Suppose that, we have 22. Yeah, we have approval refund service. So we after our evaluation, we believe that your credentials are good, you have a great chance of an NIW approval, we will provide approval refund service, which means that if your petition gets denied, we'll refund the attorney fee.
That's it. I don't see any more questions in chat box unless I missed any of them. So everyone, please, if I missed your question, please, you can ask your question yourself, or you can remind me, or you can type again. I hope I haven't missed it.
Hi, very nice talk. I have one quick question. So
Sure.
I did my green card with you, right? And then my friend also working with you. But now what we found is that there is the two way of preparing the document. One is the expedite way of preparing the document, which goes pretty quick, and next one is usual like we have done, which took about 3 to 4 months. What is this expedite processing? Could you please explain that one? I got confused explaining him.
Yeah, for sure. Yeah, so first of all, like I said, right now the US's processing time is so long, and some of our clients that really want to kind of shorten the case preparation time with the hope that they can get their green card a little bit faster. So we're always brainstorming how to best help our clients to get their green card a little bit faster. And one way we kind of feel that we might be able to file the case faster without compromising our client's chance of case approval is to lower the number of recommendation letters, because we kind of find out that when clients' objective credentials are really strong, those objective credentials speak for themselves. So even if we submit fewer recommendation letters, the chance of case approval doesn't seem to be compromised. So we usually submit 4 to 6 recommendation letters. That's probably what we did with you. But now we feel that if client objective credentials are strong, then we can lower the number of letters to be 2. And we can draft these 2 recommendation letters together with a petition letter, and we can finish them in 12 business days. So in that situation, we can make the case preparation time shorter, and be able to file clients' cases faster, and hopefully they can get their green card faster. But we only do so for clients with strong credentials. So if the client's credentials are not really strong, we still want to provide like a more comprehensive documentation to the USS. So in that situation, we still submit 4 to 6 recommendation letters.
Excellent, thank you.
Hello, yeah, thank you for the presentation. I have very quick question. I just recently got the green card from your process, but actually, I am the beneficiary of my wife. My wife applied as a NIW, as a F2 visa, from the F2 visa, and we got approved. But she is still looking job, but I am as a working continuously. So does it any like matter for whoever working between us, like my wife or me? I think
Yeah,
using
Yeah, with a green card, you can work for any job of your choice. So because you are a dependent of your wife's, NIW case, your job doesn't matter. You can do any job that you wish. But for your wife, like what I said, we usually suggest clients to continue to engage in the same field at least for 6 months after they get a green card. So for your wife's job, it has to stay in the same field that we claim in her I-140 NIW petition.
but she was in unemployed while applying because she was in F2.
But did you say that you guys already got your green card or
Yes,
no?
yes.
Oh, okay. Yeah, so it's okay if there's a short period of time of unemployment, but now she has her green card, she can work, right?
Yes,
Because green
yes.
card serves as, so she should start to look for jobs,
Oh, okay.
yeah, in her field.
Okay. Okay, thank you for nice talk.
There is one more question in chat box. Victoria, can you see that, or you want me to share it? That should be the latest one.
Okay.
Or I can read it for you quickly. It says, you mentioned that the attorney fee is $5,000. Can that be paid in installments? if somebody does so, will the cost be higher?
Oh yeah, for sure. So our standard installment plan is that we split attorney fee into two installment. 50% is due at the time we're retained, another 50% is due at the time we file the petition. But if you want us to split the attorney fee into more installments, we're able to do that. So the overall attorney fee wouldn't be higher. So we don't charge like interest or anything like that if we need to split attorney fee. It's just that if we do split attorney fee into more installment, we do monthly installments, just more convenient for our financial department. And we kind of utilize this app called Stripe. So I think they charge like 2% credit card processing fee on their part. So that's their part, like a processing fee, so a little bit more. But on our part, yeah, we don't charge more if we have to split the attorney fee into more installment.
All right. One, let's say, last final question is that is there an extra attorney fee for expedite case?
No, yeah, we charge the same.
Wonderful. So we are almost close to 2 hours. So I would like to thank you, Victoria, again for such a nice presentation and so much informative. I hope our audience, everybody have enjoyed it and should get benefit from it. And most of us obviously will be taking benefit from again you in future. And for audience, if you have any more question, you can send us. Some of our community member might have the answer for them. Otherwise, we can again reach to Victoria for more authentic answers. So thank you everyone, and thank you Victoria, especially thank you so much.
Yeah, you're welcome. Yeah, thank you guys for listening to this presentation. Yeah, again, feel free to reach out to us if you want us to take a look at your credentials. If you're current clients, leave a message in our case management system. As you're aware, we respond to clients' inquiries within 24 business hours. Yeah, feel free to email me if you have any other questions. Other than that, yeah, thank you so much, everyone. You have a great weekend. Thank you.
All right, thank you everybody.